Sure, yes, Judge, no, Joe.
Good morning, Mr. Child. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Yes, Your Honor. Law enforcement officers were dispatched to a disturbance at 70 Carlton Woods Creekside. Law enforcement officers observed a white male sitting on the curb of Kukendall Road, arguing with his girlfriend on a cell phone. Law enforcement officers law enforcement officers had received an additional call of a disturbance of two parties coming from neighborhood, two individuals coming from a neighborhood party. They observed the complainant and defendant to be highly intoxicated. An Uber had picked them both up, and they both started fighting in the Uber. The Uber drivers pulled over.
Fighting in the Uber?
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was his girlfriend, who was the defendant's girlfriend. And the Uber driver had called the security officer on duty to get help with the situation. I'm sorry, Your Honor, it's reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Actually, stay close to that area, will you? Don't come here. Stay close to that area.
Yeah. Okay, sorry.
So we're just doing PC. All I've heard so far is that they're both highly intoxicated, arguing. He's allegedly punching and slapping in an Uber car. That's all I've heard so far.
So then Uber driver pulled over, called the security officer on duty, but the defendant got out and started walking. The security guard followed him until he got to the beginning of the subdivision. Then officers arrived and observed the defendant on the sidewalk. Officer tried to talk to the defendant. And the defendant started to tell the officer, quote, "Leave me the fuck alone. You people are a piece of shit, and that's all you'll do is treat people with no respect." The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they're trying to hide. Defendant said that that's my marijuana. Defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said they were a party, they both got drunk and started fighting when they got in the Uber. And the complainant witness stated that she did not feel pain. I think that's where we're at.
Do they see any visible injuries, anything of this nature?
Well, Judge, as far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically that the punch was of such a force that it caused her to fall to the floor of the vehicle and cover her face after she was punched. So I think that's where we're at with that.
Again, Judge, to answer your question, there's no indication that there were any injuries at all, any marks, and as he just read, she said she did not feel pain, she did not want to press charges, and I have an affidavit on prosecution as well that I'm going to be getting to the state.
Yeah, so as far as bodily injury goes, of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, a punch of a certain amount of force from a witness's
Did
perspective.
they get any statements from the person who saw the punch to,
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
the officer goes to interview the complaining witness, I'm
Yes.
assuming, and doesn't see
And
anything?
I don't see any indication that they saw anything.
And she says, I felt okay. And I do not want to press charges.
Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of a bitch they have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases, you start racking up convictions. All you're doing is you're hurting yourself. Be nice and good things happen. You're aggressive to cops. You're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. But don't drink if you're going to be in jail. Really. We have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge.
Takes a driver's license and no driving license. On the state side. Side reset.
Good morning, Ms. McKnight. Ma'am, you're charged with two cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine.
I do that, Tony.
First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to
I
you.
get that, Tony.
Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" After you broke my window of the vehicle of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number, threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check here.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm praying about that person.
I don't want you to have contact with this person. Do you understand? You understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's two sides to the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about, do I have to come to court so I get in contact with him because we have a child?
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in these cases and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box while I find you a lawyer. Don't leave until you sign our bond conditions.
In your honor,
Okay.
you want to wait for the board to set bond on the new case as well?
Yeah, I guess so.
Yeah, you don't need to ask you here for the rent, right? Yeah, see.
Yeah.
Okay.
I mean, as long as it grants for some bond conditions, but.
Yeah, we don't need it.
So you ready?
Yes, sir.
You are Mr. Saran. Sir, you're charged with criminal trespass, facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Law enforcement officers received a call for service where an individual stated that somebody was trying to break into her home. Officers observed the defendant matching the description given by a caller around in the area. Officers made contact with the defendant and he was identified by previous booking videos as well as his SPIN number. Officers made contact with the complainant on scene, who advised that the defendant was trying to break into her home. Complainant stated the defendant knocked on the front door, rang the doorbell, and looked through windows of the complainant's property. Complainant observed the defendant entering her backyard, stand on top of a shed to look into windows, and attempt to pull on a door handle to open the door.
And it's only a trespass.
Complainant has surveillance footage of the defendant on her property. Officers searched the defendant and found an unused pipe that officers' training experience indicates it was used for meth. Defendant stated he was a frequent user of methamphetamines. Defendant further stated that during an interview with officers that he was looking for items of value at the above residence in order to obtain money for drugs since he was currently out of money. I think that the reason it wasn't charged as a bird cab is because he wasn't actually able to make entry into the residence.
Mr. Saran,
Yes, sir.
since 2023, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and now 11 in a matter of 14 months. If I find that you're using any kind of dope, I'm going to take care of it in a way that you're really not going to like it. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. You're ordered not to use anything. And if I find that you do, and if I find that you become a danger to my community, I will grow a horn and tails. Do you understand?
Yes, sir.
I'm putting a GPS monitor on you so I know where you are at all times and I don't want you out in the middle of the night.
Yes, sir.
It's time for you to stop using. I'm giving you now the opportunity to do it on your own. If you're incapable of doing it your way, then we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Please appoint him a lawyer. I'm sending him now for a drug test. You were to go test and you were to come right back. I just want to know what, if anything, is in your system.
Yes, sir.
If you fail to test, if you fail to come back, I will issue a warrant. No more PR bonds. Do you understand?
Yes, sir.
Take a seat for me. What page?
Page 31, top of 30.
Mr. O'Neill,
Morning.
Sir, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. All right.
Good morning, Judge. Just 1 second, pulling up right now.
Okay.
Sir. I thought I was supposed to have an attorney here today.
Did you hire one?
No, the judge that I talked to said that I could have.
That was for purpose of magistration, but it doesn't carry with you until the end. You don't have a lawyer at this time.
All right, Judge. On April 12th, 2025, officers responded to a family disturbance call in Harris County, Texas. The officer ID'd the complaining witness by their Texas ID card. The complaining witness stated that the defendant threatened to shoot her. The complaining witness ID'd the defendant by his Texas driver's license. The complaining witness stated that she is the defendant's daughter and they all live together in their grandfather's residence. The complaining witness stated that the defendant threw her clothes outside. The complaining witness stated she asked the defendant to go get them. The complaining witness stated that the defendant stated, "I have something else for you," and then took his hand and pointed it at the complaining witness, stating, "I'm going to shoot you." Complaining witness stated that they were in fear due to multiple guns being in the house and the defendant having a violent history. The complaining witness stated she observed the defendant holding a black long gun. The officer detained the defendant. The defendant refused to ID himself, repeatedly stating, "What is going on?" The Miranda rights were read. The defendant denied all allegations and stated his daughter, the complaining witness, was lying. Defendant advised that he hadn't seen the complaining witness all day long because she was at the hospital visiting her mother. The officer inquired about this, and the complaining witness stated that she did not go to the hospital. It was only her grandfather who went. The complaining witness stated that she was home and the defendant did see her and threaten her.
All right, Mr. O'Neill, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. These are your bond conditions. If you violate these conditions, I will revoke your bond, put you in jail.
Absolutely.
Do you understand?
I don't have.
Just don't say anything at this point. Just don't have any weapons. Don't have contact with this person. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they will potentially file additional charges against you. Do you understand?
Yes.
Okay.
What about the house? That's where all my stuff is
What I'm
at.
going to do is I'll appoint me a lawyer today. You can talk to the lawyer about what's going on, but I'm going to do everything in my power to protect everybody in this at all costs. You understand? Okay. So look,
She can go wherever she wants, but I'm just asking.
let's do this. Let me appoint you a lawyer. You can talk to the lawyer and we can go from there. Now is not the appropriate time to go through this.
I've been staying at a shelter
Okay, hold on.
and
I already have an application. So Vic, do you mind appointing him? I already have an application on file. For now, what I'm going to have you do is I'm going to have you sign a reset with Victoria while you take a seat in the juror box while I find you a lawyer. We'll have you talk to this person and we'll go from there.
did the reset happen in a few days.
We usually do like a month.
Months.
I'm going to have you talk to a lawyer today. Okay. My sole issue is protecting as many people as I can. That's what I want to do. I know, or it may come at an inconvenience to you, but I like to follow the wishes of the complaining witnesses because I don't want them to live in fear. There's nothing worse than having to live in fear, having to walk on eggshells, and that's what we try to prevent here. And I know that you have your side of the story, and there's always two sides of the story, but the best recipe that I usually find is keeping people away from themselves. The problem is that may be a disadvantage of you because you may have nowhere else to go. But what other choice do I have? I don't know, right? Tell me, you were able to speak to her.
Yes, Your Honor, and I'll relay the message she gave me. So just a little bit of context, the defendant is her father, is what she says. And she says she's had no contact with him since the incident. But she does say she's been getting updates from family about the defendant that she's not asking for. She said that she's getting married and planning on starting a family, and her heart's desire is to have her father in her life, but she said that he's proven that it cannot happen. She states that she is done with her relationship with the defendant. The defendant has not changed. She wants no contact. She's currently working on making her restraining order permanent. She states that the defendant is not trying to get help. She states that she wants anger management, Alcoholics Anonymous, and Narcotics Anonymous treatment.
So there's drug issues and alcohol issues.
According to the complaining witness, Your Honor, yes. So we know about the situation.
Stop. Don't say anything. Just don't.
And so we know about the situation where he needs some of the items he has at his place. She says that she has them placed in bags. She says that she's either told the family to handle giving the items to the defendant, or she is okay if the defendant comes with officers while she's not present.
So she obviously lives at that house?
Yes, Your Honor.
Who, is it grandfather's house? Whose house?
I'm not sure.
I mean,
It was the grandpa's house, his father's house.
I,
But he had actually moved in there to help out with his parents and, well, I told you, he strokes at both times. Judge.
yeah, but I can't, she's living there and, it's,
So I'm told that his daughter is a drug user, Judge, and that this happened late at night. In fact, even in the DIMS, it says that this alleged
I mean, I
assault.
can't really,
No, but it says alleged assault happened at 2:30, but we didn't call the police until 4, I believe. And she mentions a long gun, but there was no guns found at the scene.
I don't know. I just don't want you to, she doesn't want to have contact with you. So don't have contact with her. Don't use any drugs. Don't use alcohol, and making that a condition of your bond as well. I don't know what to tell you, but she lives there. And if I allow you to go back to that house, it's a recipe for disaster.
Judge, he does live with his parents and does nowhere else to stay right now. He's been living at the Star Hope shelter for a week. In fact, they arrested him in his underclothes and he's wearing clothes that were given to him.
Well, I mean, like you said, he can go back and get the stuff. He's got to go with an officer. And at a time that she's not going to be there, I guess we could work that out.
His ID and cell phone, all that are at the house and they can't
I
get
mean,
that.
she has it in bags ready to give to him. You know what? Also do this. If you want to, we can roll this to tomorrow, but will you also reach out to, I guess, the homeowner and get their opinion? Are they okay with him coming back? Perhaps you can get their side as well and see what they say. So we get like a neutral and detached person to see, is this because he obviously wants to go back to the house? We know that she doesn't, but the problem is that if I let you go back to this house, you will invariably at one point or the other, you're going to run into her, and it's going to be disastrous because it always is, and then you're going to end up back in jail. You're out because we gave you a free bond right now. You need to understand that if you go back, you probably have no one in this world that's going to pony up 5,000 to 10,000 to get you out. You will be stuck like Chuck. You need to consider these things when you're out there. I'm not asking much from you. I just don't want you to have contact with this person and don't have any weapons and don't use. That's all I'm asking. You want to roll this tomorrow to see if there is perhaps a way that they could kind of separate, kind of bifurcate the house, so to speak?
Again, is your father able to answer the call if they call and talk to him?
No. Well, look, I don't want you guys to talk here. Let's do this. Let's roll it to tomorrow. See, do you mind reaching out? Is there a possible way to kind of divide the house in half or is there like a garage apartment or is there like a shed or something that he could stay at? I don't know, but
That's how I've been living.
So you're separate from her.
Yeah, I'm separate from all of them.
We can talk about, he's telling me that he's separate, living away from everybody, his own room, I guess.
I want to hear it from them too.
Sure.
I don't want to hear it just from you. I want to hear it from them that they feel protected. That's my
I
only
understand.
concern,
I understand.
So we can, come back tomorrow because it's already 1 o'clock, right?
What time tomorrow?
Same time, early, 8, 9 o'clock. So
We'll be here tomorrow.
So guys, this is Mr. O'Neill. So no contact, no weapons, no going to the house for the time being, no drugs, no alcohol, random testing, please. All right, Mr. O'Neill,
Testing.
no drugs, no alcohol, and I'm going to test you to make sure you're not using. If you test positive for drugs or alcohol, I'm going to put you in jail. Don't use.
Yes, sir.
All right.
Understand.
Okay. All right. Good luck, Mr. O'Neill.
Thank you, Judge. My excuse.
Thank you.
That's yours.
You'd rather still have a seat for me? You might have a seat and I'll call you whenever they're ready.
Good. Come on.